Good evening. This meeting will come to order. This is the November 2015 Zoning Board of Appeals. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, please.
Mr. Chizola.
Here.
Mr. Haberman.
Here.
Ms. Ferrante. Here. Mr. Soda.
Here.
Mr. Vecino.
Here.
Mr. Dubois.
Here.
Mr. Thomas.
Here.
And Ms. Eggleton is...
Also present is Stephen Harris, our zoning officer, and Meg Green, our recording secretary. If anyone feels that there's a member on this board that might be a conflict of interest to their hearing, please let us know. Otherwise, we will begin.
Item number 1, 12 Francis Street, Zone R, 7.5. Kevin Kerseiden, Esquire, attorney for Antoinette Boll, owner, sections 9-2-1. Appeal the decision of zoning enforcement officer dated 24th of August, 2015, map 6, block 84, parcel 2.
Mr. Kerseiden, we're going to hold up 1 minute on the hearing because we have a technical problem here we have to address. Yep. So we'll be in recess for a few minutes.
Kerseiden for Antoinette Boll. My office is at 26 Cherry Street here in Milford. This is our appeal of Stephen Harris's decision or notice of enforcement. I wasn't sure, Mr. Chairman, if Mr. Harris proceeds or we proceed first. I don't. Okay. I'll just approach, and I have 6 sets of plans. I can give one, or 6 sets of I guess, outlines or information for the hearing tonight. I can give one to Mr. Harris, and I have 5 for the board. Just coming back on the record, I also have a full set of the construction and building plans as stamped by the building office. It's full size, I'd like to enter into the record. I have the approved site plan up here. I'll be turning that in as part of the, folding it up and turning it in as part of the record too. Really, that's just to show you where the house sits on the property. It also has some language in there for the zoning permit, which is relevant to our appeal, and I'll go over that in a minute. So the challenge for preparing for this hearing tonight was how to give you guys enough background information on a property in a situation that's rich with land use history in order for you to make a fully informed decision without overwhelming you with the facts and the law. So I try to be brief. Usually when I'm up in front of you, I'll try to do that, but I do have to give you some background information, otherwise you'll be making this decision in a vacuum. So here goes. I delivered the package containing all the documents I'm going to reference. I might not reference them exactly in the order that they're there. The Volls purchased the property in 1997. It's in Antoinette's name. That's Joe's wife. Joe's here with me tonight. It was basically a cottage, and there's some pictures in the back of that package from when they purchased it. They used it as a summer cottage for about 11 years until 2008 when it was demolished to build the existing house. The Volls, I believe, do have maintain a residence in Monroe, but are very connected to the Milford community. Their daughters have attended and graduated Laurelton Hall here in Milford, and Mr. Voll has ownership interest in several real properties and buildings on Broad Street in downtown Milford. In order to build the existing house, new variances were first obtained for the new building. I think it was with respect to setbacks. That was not part of that application. As far as I know, there's no issues with the variances. Then a CAM application and a site plan were filed. Mr. Voll was represented at that time by an architect, Mr. Grew. Those plans were approved at the time by the Planning and Zoning Board. Then a zoning permit was applied for, and it was issued in April of 2007. It was then modified in June of 2008, and this is what's written on the plans down at the bottom, signed off on by Linda Stock when she was the zoning enforcement officer. It was for a 36-foot by 56-foot overall, two-story, single-family dwelling with 2 fireplaces, garage underneath, breakaway walls, 5-foot by 12-foot front, or breakaway 5-foot by 12-foot front porch with stairs, 36-foot by 36-foot rear deck with stairs, 6-foot by 11.6-foot second floor deck, 8 by 15-foot endless pool, 8 by 8-foot hot tub on deck. A building permit, foundation and footing was issued. You can see that that's in your file. The necessary permits were obtained. There's 2 separate permit applications from the building department. One's for the foundation and one's for the construction of the house. Construction was commenced and substantially completed by October 2008. The deck was up. There was only the deck railings left to be put in place. I believe Mr. Voll's here to answer any questions about the status of the construction at that time. On October 24th, 2008, I believe I have a copy of this letter in there. It was from Emmeline Harrigan, the former assistant city planner, telling the Volls that they needed to stop what they were doing and come and get a permit, and that it was followed up by a second letter from David Sulkus stating that the Planning and Zoning Board decided to hold a hearing to revoke a portion of his permit, of the Voll's permit. Just legally, I want to comment on that, and I'll talk more about it in a minute. Under your regulations, the Planning and Zoning Board can revoke a site plan approval. There's nothing in the regulation that says they can revoke a permit. The permit issuance and revocation is strictly the purview of the zoning enforcement officer or the Zoning Board of Appeals. We appealed Emmeline's decision to this board, but there was a 15-day time limit, and you may remember us coming here. There's a few members on the board from back then. We were a couple of days late over the 15-day time period. I think it was like 17 days or something. We asked that the board hear it on the merits anyway. This board, there was a letter of guidance or advice from the former city attorney, assistant city attorney Cindy Anger. She advised why it was not a good idea to act on it. So the board declined or denied our appeal based on lack of jurisdiction because it was too late. However, I just want to point out that the state statutes provide for 30 days, but the town can limit it to 15 days if they wanted to. So that is what it is. This board decided they didn't want to hear it. So there were several hearings in front of the Planning and Zoning Board over a couple of months, and there was a ton of information put into the file. Ultimately, the Planning and Zoning Board approved a motion to revoke the portion of a site plan, which Stephen references in his letter, as well as the zoning permit. And like I said before, only the zoning enforcement officer, the ZBA, can revoke a zoning permit. We went to court over it. The court upheld that decision. I don't believe it was the correct decision, but that also is what it is. The point of our appeal tonight is that since then, and since Emmeline's original letter in 2008, there has been nothing done until August 24th, 2015, when Stephen Harris sent that letter to enforce any type of enforcement action whatsoever. No other action was taken since the board revoked a portion of the site plan. No enforcement action was brought under the local zoning regs. No fines were imposed. No fines were threatened to be imposed. There's state statute 8-12 that outlines what boards or municipalities can do to enforce zoning regulations. Nothing was done. You have your own zoning regulations that allow enforcement. Nothing was done. No stop work order was issued under Building Code Section 114, which is a copy of a sample stop work order letter in that package. The building permit was never revoked, and if the zoning permit was ever actually officially revoked by the ZEO, we never got any notice of it. My client never got any notice of it. So it's important, when you think in the overall context of this, there was a board decision from the Planning and Zoning Board to revoke a portion of the site plan, but there was never any enforcement from 2008 forward. Also, and I don't know if Stephen will agree or disagree, but what was approved by the board at that time and the building department was what was actually built. There wasn't anything built that was not permits issued for. So we have a couple of different legal arguments, and then I can go through these documents and then I'll be done with my portion. But we believe action was required either within 3 years under 8-13A, the boundaries in this case, the boundaries of the lot being the coastal resources, or within 6 years of Connecticut General Statute 29-265. That's a copy of those regulations are in your package. So there's a couple of different legal doctrines as well. There's municipal estoppel and the doctrine of latches. Latches basically meaning that the board's prevented, or the town municipality is prevented from acting on a enforcement issue if too much time has passed. There's a lot of case law on it. I'm not going to bore you with the cases. I'm just going to point out a couple of cases where an applicant claiming municipal estoppel, meaning the town's prevented from acting, or claiming latches that the town's prevented from acting because they've taken too long to do anything about it. There's a couple of cases that allowed that applicant to be successful. The town was prevented from enforcing its zoning regulations because of prior actions of its officials. No permit being revoked by the building inspector in this case is an example of that. No permit revoked by the ZEO, and no enforcement action started. That's all relative to this case. They also, if there's no significant public benefit from enforcement, that's another factor to look at. And I think the main issue the Planning and Zoning Board had was that there was coastal resources that were somehow damaged. And you can see the photographs, the before and after photographs, I believe, are in the file, in the package that I gave you of the land surrounding the house. And you could also, this is a little bit off topic, but these coastal resources are minimally impacted compared to the coastal resources. There's also a picture of 182 Milford Point Road being built down the street, right in the marsh. And then the third factor being if enforcement was oppressive to the owners. And Joe Vall's here tonight to talk about the detriment to him if he has to remove the deck, the cost that was involved with that, and the cost that would be involved with removing it. Then estoppel prevented another town from enforcing its regulations where an architect had presented the building plans, like in this case, which is why I submitted the building plans, which are stamped and sealed. On a side note, the building plans are no longer in your building department because the number of years have expired. So as far as I know, I've checked into that, those building plans are gone. So we have a copy of the building plans for you. So like in this case, an architect presented the plans, they were stamped and sealed by the town building official approving them, and then construction occurred according to the plans, exactly like happened in this case. So I just want to also point out, this is not a situation where Mr. Vall or myself is trying to claim, oh, you waited too long, too bad, see you later, haha. That's not what we're doing here. That's not the attitude that we've had from the beginning on this. There's some very serious issues here at play. One of the serious issues being, and we lost in court, so I just have to let that go. But you are the board that decides whether permits are revoked or not revoked, not the Planning and Zoning Board, which is procedurally the way this was handled from the beginning has been incorrect. It's also of concern to me, being a resident of Milford and also representing a lot of other builders and developers, is where you have somebody who gets all the approvals, gets everything stamped, does everything that they're supposed to do, hires professionals, architects, land use folks, everything else, gets the plans permitted, approved, then starts building, almost finishes building, and then somebody comes back in and says, 2 years later now, 2 years after the first approvals were given, somebody comes back in and says, hey, we think that 2 years ago you misrepresented what was on your site. We think that there was a sand dune over here, and we think that there was some seagrass over here. And I'm not being, trite or cute by saying that, but that's essentially what the claim was. And you have to stop everything, and we're going to revoke your permit that we gave you 2 years ago. So those are the serious concerns that were part of this case from the beginning, and they're still here now. But we should all be concerned if that's something that could happen to us. The reason I have the deed in here is just to show what year they bought it in. The pictures of the old house, it was an old, just simply it was an old beach cottage. I believe it was damaged or frozen by one storm or another, and it was a situation where it was either going to have to be elevated or demolished, and the Valls decided to spend the time and effort fixing it up, actually tearing it down and rebuilding it as opposed to elevating an old house, probably 100 years old. I don't know exactly, but I know you see a lot of those variances these days with Sandy and Irene. I included the original permit so you could see what was permitted, or the original approval, the original zoning permit. There's a letter in there because there was a remaining question about the pool foundation. There's a letter in there dated April 17, 2009 from somebody at it was Department of Environmental Protection, now DEEP, stating that the new pool foundation plans are acceptable if he does some cutouts. The pool is not cut. The pool foundation is not cut out right now. There's the letter from Emmeline Harrigan, from David Sulkus, the building permit applications, approvals, then the pictures of the site. I just took these. I didn't have time to get all color pictures today, but most of these pictures of the new house, I took them all yesterday. Just a sample stop work order, which is something that should have been done if the city really wanted to enforce it, and then copies of the statutes, just if you wanted to read through. I don't have anything further unless you'd like to hear from Mr. Vall at this point.
I have a question for you, Mr. Crusader.
Yes.
This was completed, I believe you said, in 2008?
Yes.
And they've been living there. What was approved was built,
Yes.
according to your statements?
That's correct.
How did this come about? It just all of a sudden came up in 2015?
No, it came back. It was, why is the enforcement coming about in 2015?
Yes.
I can't answer that question. How it came about originally in 2008 when Planning and Zoning revoked a certain portion of the permit, which is to remove part of the deck and remove the pool foundation, as shown on Stephen's letter, was, I believe, if you look at the file, I think some neighbors complained that there was work being done down there, and could somebody come check it out? And I think somebody from DEEP had come down, and Emmeline went down, and they made a determination that the resources that were on site 2 years after it was approved were not what was represented 2 years before at the Planning and Zoning hearing CAM report. That's how that part of it came about.
What basically is in question? Is it the deck, the size of the deck? And you mentioned some of the...
It's a portion of the deck, yes, sir, and it's the pool foundation, and I think part of the hot tub. It's a little bit hard to see, but if you look at this plan, the part that it looks like, if you look down at it from the top, it almost looks like a ship going out to sea. And so the deck, there's a certain portion of the deck, it's the portion that goes towards the ocean, would be required to be removed. Underneath that is the foundation for the endless pool, and the hot tub is also part of that in the deck that they're asking, or had revoked the permit on, revoked the site plan.
Thank you. Any questions for Mr. Crusader?
So
Mr.
was
Soto?
this house complete?
Yes.
Did it have a CO?
No, it still doesn't have a CO.
Okay. So it was complete, they were living in it when they got the first letter?
I don't know that he was living in it. Mr. Vall can answer that. It was substantially complete in that it was just that the deck railings needed to be put on. He put the deck railings on for safety reasons because it's about 10 feet off the ground. After there was the notice from Emmeline in 2008, the deck railings were put on. But whether there was any interior work that needed to be done, I'm not sure. Mr. Vall can answer that question if you want.
Ms. Ferranti?
A quick question. What are the resources in question that you say were present in 2008 or not present that were misrepresented originally?
Well, I just want to be clear. It's our position that nothing was misrepresented. There was that site plan that was filed What the claim was is that that site plan did not have the elevations on it. And here's part of the issue. It was accepted by the city planner. It went through the process, all the city agencies. The city planner goes to great lengths with every application that I file to certify it that it's, he can't certify what the surveyor certifies. That's not what I'm saying. But after the fact, the claim was that elevations were not represented and that therefore there was some dunes and some beach grass that were removed or that were not shown on the original plan. And that therefore it was never, the word was never used, but it was implied that there was some type of fraud or misbehavior on Mr. Vall's part. That was the claim.
Any other questions for Mr. Crusaden? No?
If I could just maybe address some things, Chairman.
We need you to identify yourself, sir. We need you to identify yourself and,
Yes.
and your address, please.
Yes, my name is Joseph Vole, and my residence is at 17 Colonial Drive, Monroe, Connecticut, 06468. Just to clear up some things, we purchased this house back in 1997, and it was our plans. Okay, we purchased that house in the original house in 1997. Our plans were to make that our retirement home. We have four girls. Once everybody's out of the house, to have a place to go, and hopefully spend the rest of our life and enjoy our children and grandchildren. So, basically, what had happened, there was a storm in the winter of 2006, I believe, or 2005, and Linda Stock, who was at the time in zoning, said that we had to raise the house raise it. So we had no opportunity to just raise the house, but we had to raise it, tear it down. So basically, we had to start from scratch and build a new home. We started the process, went through great lengths to get it approved. I'm sure you know we went through coastal site plan review. I hired an architect, me and my wife, Gregory Grew, who's done numerous houses approved on the water. And we had Codis Bodie was our engineer. And basically what had happened, we went through every process, got everything approved by every board, never had a problem. We got support from the state of Connecticut Department of Environmental Protection. We got a letter in support of the plan, got it approved, got all my building permits, everything got issued. The only thing that was up in question was the pool itself, not the foundation, because when we did the application, we found out we had to go back. Tom Rauccio told us we had to go back to get the health department to sign off. So that's the only thing. I said, don't worry about the pool. We'll get the foundation, and we'll get that straightened out later on. About 2 and a half years later, the house is substantially complete. We get somebody from Rose's Mill Pond, somebody living in a condo, put some kind of complaint in about some activity on the property. Didn't even live near the water or anything like that. It's all in the file. Sent a letter to the DEP, and therefore that triggered Emmeline Harrigan coming out to the property. And she came out to the property, and then basically, the whole process started. I didn't anticipate I was going to have a problem. I did everything I was supposed to do, and the next thing I know, she's issuing a cease and desist order on the deck or whatever. The bottom line is I did everything. Put yourself in my position as a regular citizen. I do everything. I get it approved. I hire professionals. I spent tremendous amounts of money on structural engineers, over $20,000. I did everything possible, engineers, architects, got it all approved, went through every board. I didn't build anything different than what was on the plans. Their claim ultimately became, if you read the whole thing and read the text, their argument was that I left out stuff that were sensitive maybe to the coastal resources. Well, first of all, that's not true, because back then, I went through Peter Crabtree, if you remember, was on the board. He met with me 3 times. He wouldn't even let me put the application in until he went over the coastal site plan, did everything. He went out to the site, met with me at the site. Everything was fine. They saw it. In fact, Dave Solka signed off on it also later. The bottom line is, back then, if you guys, Joe, I think you were on the board, so you're probably around. You remember back then, on the coastal site plans, they didn't have the engineer, Codis Bodie, or any engineer show coastal resources. That only became about a year and a half later. So they were trying to punish me for not having coastal resources shown on the plan. But how could you go back retroactively and hold me to a standard that didn't exist at the time? And we looked at all the plans. Peter Crabtree said there was no existence of that kind of thing. So the bottom line is, and they had no proof there was any coastal resources. They were trying to use aerial photographs from thousands of feet up imaging. How can you honestly see? And you know, between you and me, if you've been on the beach, I've lived there for over 25 years now, between the other house and this house. And the bottom line is every year the coastal resources change rapidly. You know that, beach grass, seagrass, dunes, the heights change, the winds, the storms. We have Sandy, we have Irene. Things have tremendously changed. I mean, totally, the pond out there, the lagoon has changed. Everything's changed. And if you look at it, everybody's been taking the beach grass. I'm the only one. I got like me and a couple other people have the beach grass. I haven't touched it, grown a lot of beach grass. I mean, every beach cleans it every year. You look at Lake Laurel Beach, they destroy it every year then, twice a year to clean it up. Here I am, a small little guy. Maybe they said there might have been some beach grass. Then they wouldn't accept the pictures. Gregory Grew presented pictures to the Zoning Board of Appeals and the Planning and Zoning Commission. Those pictures were exactly the same pictures he had on the board and brought in. So they tried to confuse the board and say, maybe Mr. Voll didn't show the same pictures at the Zoning Board of Appeals as the planning. I mean, come on, God. You think doesn't even make sense. I hired professionals. I brought in a professional soil scientist. Emmeline was a doctorate in soil science, and she said it was not affected the resources. They presented no evidence, professional, in the whole file you could see of anybody that I destroyed or hurt any coastal resources. And I said, I'll do whatever you want. I'll replant. I'll do whatever you want if you think something existed there. Nothing existed. I'm a little guy that got caught in the process, spent tons of money, a lot of money in legal fees, a lot of time, a lot of stress. My poor wife can't even be here because she's so emotionally drained with this whole thing. It's been going on for 8 years. Oh, so at the time when I got the notice, the house was built, substantially all built. The only thing up, the railings on the deck were not put into position. You know, when you build a house, basically you put the railings together. It's a very expensive deck. It's all mahogany. And basically, you know, foundation and footings are pretty extensive with pretty big footings. And the house has been complete since that time. We've been using the house since, I believe, around 2008, 2000. We had all our building inspections. The building department is fine with everything that went on with the property. We just never could get technically zoning to sign off, you know, on the permit. And we didn't hear anything from zoning till recently, within a few months ago. I don't know why or how, what brought it up, but maybe Steve was just cleaning up some files. That's what I believe. And all of a sudden it said, Joe Voll, look at his file, it's not complete. Let's see, look into the file, and maybe he looked into it. I don't know what he did. But the bottom line is, I'm a guy, that's all I'm trying to do is to please let me be left alone so I can enjoy my house. My wife could, my children, my grandchildren love it there. They come there all the time. I love it on the beach. I fish a lot. I love being there. And unfortunately, I got caught in the system. And, you know, I got a lot more grayer since this period of time because it's been going on for a long time. And I'm just hoping for some sympathy from the board to understand that I did do everything I was supposed to do. The deck cost me over $75,000. That's without the engineering. And as a result of the process, I had to do many structural engineering reports, which were another $5,000 or $10,000. In addition, you'll see the plans that I gave you. The only question with the DEP when they brought up what Emmeline said, the structure, the pool structure, was solid. So it would deflect the waves. So what we had to do was redesign the pool foundation. I actually went through the trouble, and you'll see it in there, wrote to the DEP, got it finally approved. I had an engineer, I spent another $3,000 or $4,000. There's drawings in there. All I have to do is cut out openings like you see there, those picture frames, 2 on each side of the pool foundation, and then the DEP and the flood insurance is fine with it. But I've sat here, I've never put the endless pool in because I don't know what to do. You know, I've got the foundation of footings, and I could modify it. I just need to finally finish it up. I mean, I can't even my financing, I can't do anything with. I'm paying 5% extra interest because I can't refinance it till I straighten out this problem. So this has been a real financial hardship for me. It really has. Thank you very much.
Any questions for this gentleman? No questions? Is there anyone else? Go ahead, Mr. Kazan.
I just want to bring up a point. I kind of mentioned it real quickly about the site plan that was filed and the elevations not shown. That used to be the custom and practice years ago, you know, in early 2000, before the storms became more prevalent, where maybe it was required by the regulation that you show the elevations and the coastal resources, but it really wasn't enforced to the level that it has been the past, you know, since 08 or 07. So when Joe Codispoti came here to the Planning and Zoning Board, and he was grilled by David Sulkus about, well, you know, didn't you do X, Y, and Z with the survey and the site plan and show the elevations? And you know, he had mentioned that that was not something that was enforced. So Mr. Vall's correct on that. So it's very, you know, it's a mess of a situation, unfortunately, with a couple of different boards and agencies involved. But I just wanted to highlight that.
Okay, thank you. Is there anyone else? Go ahead, Mr. Soto.
The site plan that zoning has, without the elevations, did they stamp that approved?
Yeah, that's it there.
That's it there.
I'm gonna put it in the.
So they
record.
approved that
Yes.
when they issued you the permit, okay?
Yes. Yeah.
Anyone else speaking on appealing the decision? No? Okay. Mr. Harris?
Good evening. Stephen Harris, Milford Zoning Enforcement Officer. First, I'd like to say right off that all of what you've heard tonight has already been decided. In a memorandum of decision dated August 20th, 2012, the Superior Court found that the actions taken by the Planning and Zoning Board in revoking the coastal site plan and the zoning permit was done in accordance with the regulations and was not unreasonable, arbitrary, or illegal, and the plaintiff's appeal is therefore ordered dismissed. I've given the recording secretary a full copy of that memorandum, and in your packet, which I gave to you, I just gave you the last 2 pages of that, rather than giving you all 22 pages or so. Now, just going to go down the list of what Mr. Attorney Kerseiden went over. Like I said, all of his argument was already heard and was already decided. What it sounds like they're trying to do is to relitigate this to you here tonight. If they had thought that the Superior Court had made a grave error back in 2012, they could have appealed to the appellate court, but that wasn't done. So what it seems like they're doing tonight is arguing something they should have taken to the appellate court. Attorney Kerseiden also claims that a certificate of occupancy should be issued per Connecticut General Statute 29-265. Your charge is to look through the Milford zoning regulations to see if applications merit a variance or if my decision is incorrect according to the regulations. If you look through your packet, you can see section 8.8, which concerns itself with certificates of zoning compliance. It says that they'll be issued if the ZEO makes a determination that the building is in conformance with the regulations. And section 8.9 reads that no building shall be given a certificate of occupancy unless it has both a certificate of zoning compliance and a certificate of building compliance. So since this, in light of the court's decision, since this house is not in compliance with the zoning regulations, that's why a certificate of zoning compliance has not been issued. And because there's no certificate of zoning compliance, there is no certificate of occupancy. Attorney Kerseiden talked a bit about State Law 8-13A. That regulation or that statute concerns itself with the location of buildings or structures in relation to the lot lines. In other words, if you build something and you build it inside of a setback, you build it in the wrong location, and the city finds out about that but fails to take you to court within 3 years, the location of that building or structure is fine. In this case, no one's arguing that the location of the house or the deck is inside of a setback and therefore is illegal in that manner. So his argument about 813A doesn't apply here. So I guess to keep this brief, I would respectfully ask the board to uphold my enforcement order for two reasons. One, the Superior Court has found the revocation of both the coastal area site plan and the associated zoning permit to be valid. And two, the owner of the property has not complied with the enforcement order dated August 24th, 2015. I'd be happy to answer any questions.
Questions? Ms. Ferranti, you look like you have a question.
Yeah, well, I think it was asked earlier, but why is this just coming up now?
I was directed by the city attorney's office to write an enforcement order to inspect the property to see if they were in compliance with the decision of the court. And since they weren't, I wrote an enforcement order, and that's dated August 24th of 2015, and they took that enforcement order on appeal. So everything that predates August 24th of 2015 has already been decided.
The Superior Court decision, again, what was the date on that? Is it August
It was dated
20th, 2012?
August 20th, 2012.
And you're also stating that from that point there, they should have appealed that decision.
Generally, if the court rules against you, the lower court rules against you, you have the opportunity to appeal to Superior Court, or at least ask them if they want to hear the case. But an appeal wasn't taken.
Any other questions for Mr. Harris?
There's no time limitations in terms of enforcement. So the fact that it was, the court ruling came down in 2012 and nothing was enforced until this year in terms of your order, that doesn't matter.
No, there's no time limit imposed by the court.
Any more questions? Mr. Soda?
Mr. Harris, so basically the court has said that everything the city has done, they did correct.
Yes.
Okay.
Anything else? No? No. All right, is there anyone else speaking and upholding the appeal?
What? Attorney Christine would get a rebuttal.
Go ahead, Mr. Crusaden.
Sure. I don't know, Mr. Harris was referring to a package. I don't know if you have a package of information. I don't have a package of information. If it was something that was given to you, I don't have it, just so you know. So I'm not sure if I can respond to that part of it, but.
You can take mine if you'd like to look through
Okay,
it.
sure, thanks.
Pretty much in the first couple of paragraphs, it states that.
Okay. Just for clarification, and Mr. Harris wasn't here at the time, but we did appeal it to the appellate court after we lost in Superior Court. And we petitioned the Superior Court, or the appellate court, excuse me, to hear it, and they denied it, which they have the authority to decide what cases they're going to hear. So we did try to take that extra step. The critical difference in what was decided by that court and what we're talking about here today, there's a few of them. One is, it's the passage of time. It's the fact that the building permit has still never been revoked, has still never been invalidated. There's been no stop work order on the building permit, so that's a different permit than the zoning permit. The second thing is, the zoning permit has never been revoked. The court has upheld the Planning and Zoning Board's decision to revoke a certain portion of the site plan and the zoning permit, but there's never been that additional step of revoking that portion of the zoning permit. There's not necessarily any time limit, except that there's a fairness time limit under those doctrines of municipal estoppel and laches that I discussed earlier, where the project was built. It's been 7 years since any enforcement action has been taken, up until August 2015. The 3-year, I would disagree, there's probably not a lot of case law on it, but 8-13A, that 3-year time limit, it says boundaries, it doesn't say lot lines. I had mentioned in my presentation that the location of the structure with respect to the boundaries, in this case, the boundaries would be the coastal resources. I also find it curious that almost 3 years to the date after the court decision was decided is when this enforcement letter went out. I also know that there was an earlier draft of this enforcement decision that was not approved by Joe Griffith and did not go out, that would have gone out before August 20th, 2015. So I don't know if the city attorney's office would necessarily agree that that 3-year time limit doesn't apply. Keep in mind that when Mr. Vall was 2 days late, he came to this board and asked for assistance in appealing Emmeline's decision back in 2008 or whatever it was, and he was 2 days late and he was denied a hearing on the merits. And now here we are, 7 years after he got the proper permits and built his house. There's now a new enforcement action, which, by the way, is not an enforcement action to enforce the judgment. Why is that? I don't know why that is. The city attorney's office in the city has other methods of enforcing judgments. They could bring a motion to compel, they could bring a motion to contempt, they could bring some other enforcement action through the superior court system. I don't know why. Why are we starting a new action? Because if we're not successful here tonight, we have the ability to appeal to the superior court, and it starts everything all over again. So the issues here are the fact that the zoning permit was never revoked, the building permit was never revoked, it's the timeliness of it, it's the fairness to the Valls, and that's it. Thanks.
Anyone else speaking on this appeal? Any further questions for Mr. Crusaden? None? Okay, this hearing's closed. I guess myself, what I'm having a little problem with is the Superior Court has ruled on this, and it seemed to have stopped there, and why they weren't able to appeal that decision from 2012, why it was denied. Mr. Soto.
Well, I feel for everything Mr. Hall went through, but I lost my train of thought here, but give me a second, come back to me.
Anyone else have any comments? Mr. Haberman?
I guess I agree with you that, I mean, there was a court judgment. There's no time limit on that in terms of enforcement. I feel bad, but, you know, I don't know if we're in a position to overturn that judgment. That's for us to do.
Anything else? No? Okay. Do we have any kind of motion? You ready for a motion? You want to make a decision this evening? We can leave this open for a while if we don't make a decision, correct?
Yes, you don't have to vote tonight.
Do we need more time to think about this? What do you think? Are you ready to, or?
I'd like to sustain it, push it back to the next month.
Okay. You want to make a motion to that effect?
I make a motion to push this decision to the December hearing.
Okay.
Second.
We have a motion to continue this to December, and we have a second on the motion. Mr. Soto?
With the motion.
Mr. Vecino?
With the motion?
Mr. Haberman?
With motion.
Ms. Ferranti?
With the motion.
I'm with the motion, so it'll be continued. Mr. Secretary, next item.
Okay. Item number 2, 62 Holly Avenue, Zone R5. Ken Persino, owner, section 3-1-4-1, vary rear yard setback to 0.3 feet, where 5 feet required, 49.29% building coverage, where 45% required. Section 11-2, accessory building to 52.87% of house footprint, where 50% is required. Map 71, block 766, parcel 4.
Hi, my name is Ken Persino, 62 Hawley Avenue in Milford. This is a resubmission from last month. I was here for a garage that was larger than the one I'm submitting tonight. This garage here is smaller in size and less variances. It's 26 by 23 feet with less variances. And one thing I want to also point out was the rear setback that I'm requesting is 0.3 feet. And according to my neighbor's property that are in the same block as I am, the house on 60 Hawley Avenue is actually encroaching over on the right-of-way over their boundary line. 64 Hawley Avenue, their garage is 0.3 feet from the property line. 66 Hawley Avenue is 0.3 feet for their garage off their property line, and 68 Hawley Avenue is 0.3 feet from the second house to the property line. So I feel that I'm submitting a property that is in line with the community surrounding me.
Your garage right now is 26 by 23. What was it before?
29 by 23.
Okay. Any questions for this gentleman? He's made a few changes since last month. No questions? Anyone else speaking in favor of this application? Please come forward.
Good evening. My name is Jim Parati. I live at number 5 Duval Street. I want to speak in behalf of the applicant. Let me just say that I really appreciate the work that you all do. I've served on boards and commissions before myself, and I know there's difficult decisions. I just want to say that we have a nice community in that area of Woodmont, and it's really a joy to see people make improvements on their properties. And I know you have to make decisions based on regulations and those kind of things. But from a human point of view, from a community point of view, I have to say that there's a number of people who have made improvements on their properties and who have gotten variances, and variances that have had far more significance than this. I do know that Ken has made, wants to make positive change, and he's been very sensitive to the adjoining property owners. You do know that we have an apartment building at 60 Hawley. It's an absentee landlord, so it's that kind of a situation. I do believe that this will have little impact on adjoining property owners and will be very, very good to for the community. And that's what I have to say.
Thank you, sir.
You're welcome.
Anyone else speaking in favor? Is there anyone here opposed to this application? Any questions for Mr. Pacino? Mr. Soda?
No, I just want to thank you for taking the board's advice, and looks like you made it smaller and it looks nice on the property now.
Thank you.
Room on each side of it.
Thank you.
Any other comments? Okay, this hearing is closed. Yes, Mr. Pacino came back and went along with some of the suggestions we had made last time, so for being cooperative and trying to work for a solution is really a plus. So I think he's made some necessary changes, and I'm in favor of this. Any other comments or motion?
make a motion to approve.
Second.
Approval is based on the narrowness of the existing lot, and everything's to be built according to this site plan.
We have a motion to approve, and we have a second on the motion. Ms. Ferranti?
With the motion.
Mr. Haberman?
With the motion.
Mr. Vecino?
With the motion.
Mr. Soto?
With the motion.
I'm with the motion. It's approved.
Item number 3, 743 East Broadway, Zone R5, Matthew Renato, Martinez Couch Associates, for Kenneth Keene and Ann Keene, owners section 3-1-4-1, very front yard setback to 9.4 feet, where 10 feet required, to 4 stories, where 3 stories permitted, map 22, block 474, parcel 20.
I'm up. Good evening. My name is Richard Couch with Martinez Couch and Associates at 1084 Cromwell Avenue in Rocky Hill. We're presenting to you the variance for 743 East Broadway, and it is the property owned by the Keenes for Kenneth and Ann Keene. Ann Keene is here with us tonight. And Kenneth has just had a procedure and he's not able to be here, but Anne will speak on his behalf at the appropriate time. The 743 East Broadway is strategically located on Long Island Sound and experienced flooding and damage during Storm Sandy, and has been very fortunate in being able to get the benefit of being in the Department of Housing's Storm Sandy program. And the Storm Sandy program has been able to assist in elevating the house above the 500-year storm elevation. The Keenes at the moment have a 2.5 or a 3-story finished house. And by elevating the house to be above the storm, the 500-year storm, would now place the house at a 4-story house. So the 4th story would be a finished story. So where 3 stories are permitted, the house would now have a 4-story house. There's also, in the front yard, the Keenes and Keene has applied for through medical need and has been approved for a reasonable accommodation, because with the house being elevated, for an assisted elevator, or it's a lift, a vertical lift at the front of the house. And the only functional location for the lift show you on here. The only functional place for it, if you're standing on East Broadway looking toward the Sound, this is the location here. And this sits, because this is the only functional place to come into the house because of the internal layout in the house, this is a lower level door with steps coming up through here, and it's not a split, it's not like a ranch style, but as you come in, the interior layout, the architecture of the house doesn't allow for the elevator to come up and then to come down through here and through into the house. And so this would require a variance on the front yard from 10 feet to 9 feet 4. It's a 6-inch encroachment into the front yard. And those are the two variances. In our package, we've put and included the variance history of the property and all of the other information that Mr. Harris has advised to present to you.
Please state your hardship.
The hardship is in elevating the house above the 500-year or the flood elevation to be able to protect it against future storms. We are creating the 4th story. And the hardship for the front yard going from 10 feet to 9 feet 4 is to be able to provide a medically certified need for vertical assistance rather than being able to walk up now the stairs, because the homeowner can't walk up the stairs, needs a vertical assistance. The most appropriate place to be able to put that elevator is at the right-hand side of the house.
The biggest question is the height of the house. What is the total height?
Oh, the total height of the house is 30, from grade, I think it's 33 feet. 7? 33.7.
When it's raised, it'll be 33.7.
Correct. The total height of the house does not exceed the allowed height to midpoint of roof.
Okay, so there's not going to be a garage underneath. You're just raising the house.
Correct. And it's a house on columns.
Okay.
It's not enclosed.
Thank you. Any questions?
I think you answered my question, but you're not increasing the footprint, you're just raising the existing house and adding the lift in the front.
Correct.
Okay. It's 3 stories now. It's going to be 4. And I believe that's something that's coming up anyway, question. Anyone else speaking in favor of this application?
I just have a couple questions for you. Did you look at taking because I personally don't like the way the lift looks there, but if you pushed it back, you probably wouldn't need the variance. Did you think about pushing it under the house a little bit? The depth of it, push it under the house and just come right up straight into the first floor?
Oh, pushing the elevator into the house?
Yes.
If we, the footprint of the house itself, the hardship then is that you'd lose a significant part of the interior living space. I mean,
just pointing it out to you. I mean, if they have trouble with the stairs, you might want to take the elevator and run it all the way up to all 3 floors, just, and push it into the house in that way.
There are things that we would, and this is
room
not
for
meant at all in a flippant way. There are things that we would like to do in a design.
Right.
The program will not allow them to occur.
Gotcha.
And so we would like to be able to take people up multiple floors, but the program is to get them into the house. That's it. And so it's to do it in the most expeditious way possible, in coming up through. And we'd looked at...
Because it's always cheaper to do it the first time, you know what I mean? I have one in my house that was in there when I bought it, and they put it up to 1 story, and then 3 years later, he had to raise it up 2 more. So,
yeah.
And then I bought it as it was, but if they have trouble with 1 set of stairs, now they got the other 2. And one other question, how far from the water are you? Are you in the AE zone or the VE zone?
The house is actually in both.
Oh, it's in both, so, okay.
And we're respecting the V zone.
Go ahead, Mr. Vizino.
Just for clarification, so the elevator is only going up to the 2nd floor? Is that where it's stopping? Is that what I just heard?
Correct, the new 2nd floor.
The new
As
second floor.
the existing 1st floor goes up,
Yep.
which is the main entry floor, the elevator will provide access to the entry to maintain entry just into that main. What will now be the 2nd floor, will become the 2nd floor, is currently the 1st floor.
Okay. Thank you.
Any other questions? Anyone else speaking in favor of this application?
Yes, we have the homeowner, Anne Keane.
Ann King, 743 East Broadway. I would appreciate any help that you could give me. It's getting hard for me to make the steps. The 405 that I have there are wonderful, but with being hit with Irene and Sandy, it's no longer feasible for us to keep the house at the level it is. It needs to be raised, and I would appreciate any consideration you can give me.
Thank
That's
you.
about it.
Thank you. Is there anyone here opposed? Any more questions for this gentleman? Gentlemen? No? No? Okay, the hearing is closed.
Thank you.
Small variance in the front. The question was aesthetics, Mr. Soda. That was, I think that was a reasonable
Well, I was
thing
just saying if
thing
they
to point
pushed
out.
it back, but, you know.
The height is going to be okay. And I believe stories, 3 stories versus 4 stories is not going to be an issue. Pretty soon, it's just going to be the height of the building.
Yeah, trying to push the Planning and Zoning Board to move on that.
Okay, we need a motion.
Make a motion to approve.
Second.
Approval is based on the site plan submitted and the hardship stated.
The motion to approve, and we have a second on the motion. Ms.
Mr.
Ferranti?
Chairman, what was you have to state the hardship on the record.
Did he state? He did state the hardship. We're going to have to ask our secretary.
Mr. Chairman, if board members find a hardship, they can state, the board members themselves can state what that hardship is and then fold that into the motion.
Yes.
They
Yes.
just want-
We're asking for what he had said, what the
I guess
hardship
it would
was.
be nice if I put on my microphone. Mr. Couch stated that for the front yard, it was the only feasible location for the elevator, and that the reason the request for the 4th story was being made was to mitigate flood risk, and that they had no choice but to elevate the house.
Mr. Soto, please.
Okay, it's
state that.
based on the hardship of it being a small lot and the only place to put the elevator is the front of the house.
We have a motion to approve. We had a second on the motion. Ms. Ferranti?
With the motion.
Mr. Haberman?
With the motion.
Mr. Vicino?
With the motion?
Mr. Soto?
With the motion.
I'm with the motion. It's approved.
Item number 4, 691 East Broadway, Zone R5. Dan Orth, agent for Pochon Kim and Victor Nye. Owners, section 4-1-4, very north deck stair to 4.11, where 8 feet is permitted to extend deck on north side down the entire length of building and deck. Map 22, block 474, parcel 7.
Good evening. My name's Dan Orth.
Go ahead.
My name's Dan Orth. I represent the homeowners for 691 East Broadway. And we're just looking to extend the walkway from the front of the house.
Hold on 1 second. You need his address, don't you?
I actually have it.
You have it? Okay.
You can
Go ahead.
speak into the...
Go ahead,
We
sir.
do it.
Continue. Just speak in that microphone.
We'd like to extend the deck, the walkway from the front of the house
You won't
down.
have to bend.
What's that?
Lift up the microphone. You won't have to bend. We want you to be comfortable.
Okay. Just looking to extend the walkway that's been approved and on the one side of the house to connect it to the back deck. And relocate the stairs from one side of the deck and just continue the stairs down the walkway.
You know what we need? We need a hardship. It states here, small non-conforming lots, and that's what everybody says all the time.
Yep, the hardship would be, we'd like to have another second form to get to the street. If something, an emergency where that door, the front door is blocked, the only way to get to the front street would be go down the back stairs of the deck to the beach and then around to the street, which during high tide, most of the time that water comes right up on probably underneath the deck, and getting down the stairs that way wouldn't be accessible.
Okay, and the size of the house is 24 by 45.
Right.
If the house was a little narrower, you wouldn't even need this variance. Mr. Soda?
Is this a new house?
It's
Yes.
under construction.
Under construction.
So your hardship is to get from the back of the house to the front of the house?
Yeah.
And you can't walk through the house?
But if there was an emergency and that only entrance to the street is blocked, a fire or for whatever reason, the only way to get outside of the house is go down on the deck.
But if
down
there's
the
a fire,
stairs.
you have a back door to go out, right?
Right.
So you're just trying to connect the two decks.
Right.
Is there a survey? How wide's the walkway going to be?
4 feet.
Do you say this house is under construction right now? When was this approved?
Yes. There's nothing there right now.
Approved for, the
Just-
building permit approved,
Just
or?
the pilings are up right now.
Got it.
Just give them a minute to look over these things. Do you know the total square foot of the house?
It's not offhand.
Mr. Chairman?
Yes.
There's already a special permit in place to build the house that you're looking at. Just for your knowledge.
If we approve the variance, it still has to go through planning and zoning for a special permit.
It already has a special permit for the house that you're looking at on that site plan.
Oh, that's been approved.
Yeah, if you grant this variance, they'll have to amend the special permit.
So, Mr. Harris, you're saying that this already went through the Planning and Zoning Board and they approved the prior version of the plan without this. They're obviously asking to add this on.
Yes, they're asking this as something extra.
So are they just including the middle walkway or the set of stairs new also? The front and rear stairs, are they new or were they on the original design?
I don't recall, but the site plan that you have in front of you is what the Planning and Zoning Board approved.
Do you know if
The front stairs were on the original.
And they were 4 foot wide?
Yeah.
And the back were 4 foot wide?
Yeah, we're just going to connect it, because it was 4 foot wide from the front, we're just going to connect it, make it 4 feet straight back.
Well, why didn't you need a variance for the stairs and you only need one for the walkway? I don't get it.
We're going to need one for the walkway and the stairs.
So the stairs you're applying for also, just not, because it looks like you're just doing the walkway.
Oh, well, we're doing the stairs. The stairs are originally approved for the opposite side of the deck. And we're just moving over just to keep it all on the same side.
Right. So they said approved steps and approved
Now,
land.
why aren't you going like 3 feet or a little over 3 feet to be code? 4 foot's over. I mean, you only need 36
We were
inches.
just going 4 feet to match the existing.
Existing what? You're moving the stairs.
Well, we're keeping, the stairs in the front, from the front of the street that go up to the main level of the house were approved for 4 feet wide. So we're just continuing that walkway down the side of the building, the 4 feet, and then continue with the stairs down.
Well, that's where I'm confused, Mr. Harris. If they didn't need a variance for the front stairs, and those are 4 foot wide, why do we need one for the walkway?
Is it just because it's a continuance down the whole property line?
It's because that's the 10-foot side of the house.
Right, but the front stairs, he said, were there on the original plan, the 4 foot front stairs. And he's just continuing that line straight back. And then
The nature of the special permit was to build a proposed deck within 25 feet of mean high water. The rest of the building was what it was. They were going to elevate it up and then add on the deck in the back. That triggered the special permit.
Oh, but this is a brand-new house, right?
It's under construction. It's under construction.
It's a brand-new house. It's not a lift. They didn't raise it.
Correct.
But
there may be some zoning history I don't remember off the top of my head.
Okay. I just think 4 foot's wide for a set of stairs when you're asking for a variance, and you could go 3 foot.
Mm-hmm.
Are you?
This is the
hold,
homeowner.
hold on one second. Hold on. Any questions for this gentleman? No? Okay. And anyone else speaking in favor? Are you speaking in favor? Please come forward. Identify yourself and your address, please. Thank you.
Sorry, I don't know if you can hear me. My name is Po Chun Kim. I'm one of the owners, or rather, I'm the owner. Victor Ng is my husband, of 691 East Broadway. I think the confusion, maybe I could clarify, is that the original house was there, and we were going to elevate it, but because it took so long and we got the special permit to do that back in October 11, 2013, it has become so dilapidated that we now have to take it down and actually elevate and build. So the prior approval, it's there. We're not touching anything or asking for any appeal. The only thing is because the stairs originally were to go up to the landing that goes into the front of the house. And then you'll have to walk through the house in order to get out to the deck. And therefore, we were just proposing under this plan to really extend that stairs all the way to the front of the deck. First, as what Dan said, to allow for another alternative in case there's high tide that we can come up that stairs. There's some ways of getting out to the street level, and then, through that walkway so that you can use the other set of stairs to get out. Secondly, there's also another alternative for an extra egress in case of emergency. Let's say the house, if there's anything, a small lot, there's no other ways but to jump from the window. But at least if there's a walkway there that links the two stairs from the front and the back, you could climb out the window and actually get out. So I don't see any difficulty to anyone other than it's really more of not a hardship for us to, have this. It will be, I think, a lot better for all of us in case of any emergencies.
The front staircase, that's the actual front entrance. Your front entrance to the house is going to be on the side of the house?
Yes, unfortunately. And so it fits, if you see the approved steps from the road to the approved landing, that actually ends into a doorway to the house. And so there is this gap there between the front landing, approved landing, to the proposed, the steps, proposed relocation of steps to the beach level. And that is the proposed walkway that we want to link it.
Thank you. Any questions?
I hope that clarifies.
You did clarify things. You did, actually. Any questions?
Yeah, and I just reiterate, I think the chairman's comment that you could have that, even though it's, to me, it's not a necessity if you change the width of the house. You know,
But given-
you have egress and ingress, you have way in and out on both sides of the house. You just want to connect the two, and that, to me, that's not a necessity you need to have, that's something you want to have. And you could have it by simply just making the house not as wide, by 3.89 feet.
I mean, it's just trying to make it, even, as opposed to having a jog back from a 4 feet to a 3 point something and then down to a 4 again. Would that really be necessary? I mean, it's on the side of the house, and it's a few more inches.
It's a matter of being a hardship or something that, you would just like, that's not necessary. If there's other ways of doing things, the house is under construction, so that's why we're thinking along those lines. If there was an existing house and it was being raised and it was already in a particular footprint, that would matter. But when there's ways of preventing hardships or giving something just because it's desired, that's why we look at it that way.
Well, I can say the hardship is, since the last two storms, Irene and Sandy, we've been having a lot of hardship trying to get this done, and it's been 4 years. And we've spent tremendous amount of money and resources drawing and redrawing and resubmitting. And I just get to a point where if this is already drawn and it makes only a few inches, but it doesn't encroach on anyone, can we just have a simple approval at the mercy of the board so that we don't have to go back to the drawing board and restart, paperwork again? Because eventually when this is built, the plan has already been submitted to my bank. It's submitted to every place there is, so when they give us the certificate of occupancy or any approval, they're going to look at the plan and see what they've built. And I just don't want that discrepancy. So I think the hardship for us is really trying to go back again to something that's already drawn. And at the same time, as I explained, the connecting those two staircases will alleviate or at least provide the extra egress in times of emergency, in the event of any emergency.
The house that was there what was the size of the house? Was it 24 foot wide?
I think it was.
Mr. Harris, we have any idea what the previous house was?
I don't remember.
I don't recall.
We don't know. Okay. If you would like to talk, you have to identify yourself and tell us.
You have to identify yourself.
I'm Susanna Lee, live in 716 East Broadway, and all the neighbors, they have, the stair, it's just from one end to another. And this house, before, has a wraparound deck in 4 feet on both sides and 4 sides instead. And, it makes sense if they come from this end to go to the other end, and it's a 4 feet. So I don't know what's the problem, because all the houses, they are doing the same thing. They have, the stair, it just go from one end to another.
They would have to come before this board. It's not that it's not, like you said, it's not a problem for anyone else, but if we keep going out with all the houses to all the property lines, there's no room between the houses, and they would have been given a variance to be that close to the property line. This house requires 5 feet on one side, 10 on the other. You have the 5 feet that's being built on the one side. You're asking for 6 of those feet to be given for this variance. So it's not like your statement has said that everyone else is doing it, because they're not doing it without approval. I'm not trying to give you a hard time on this, it's just, you know.
Look at the other house.
We do give variances, that's what we do here. But things have to be sensible and have good reasons why.
I don't know if I can refer back to your variance that was given. We've got the approval that was on record on October 11, 2013. So that's already done. This is a separate one just for that walkway. We have received.
But that was for when you were raising.
You have approval for the front staircase.
That was approval for raising the house, correct?
For
elevating the existing house.
And also the side yard setback to 8 feet where 10 feet is required. And where front yard to 0 where 10 feet is required. And then 4.1.4 projection of 3.6 feet where 8 feet is permanent to elevate existing legal single-family home and add a second floor in accordance with an application dated September 20th, 2013. I have a copy here if you need it. But what Susanna has said, which I forgot to mention, is the previous house that was substantially destroyed, it actually has a connecting deck. One in the front facing the beach, and one at the back that starts from the street to the entrance of the house.
I guess my question to you was, if we knew what the dimensions of the previous house was, and if there was a deck that ran from the front to the back on the side, like the one you're proposing, then that's different. And I mean, you had that, and the storm took it away from you, and I think, you may be entitled to have what you had. But I would need to know that, in fact, that house had that, and it was the same dimensions, that you're not encroaching any further with this new plan.
Right.
But I don't have that.
Yeah, right. I didn't mention it, but it does, and I know what you mean. So this time round, we're not going to do the same footprint, which we eliminated the deck from the roadside.
This is the same footprint.
You know what we're going to do?
Yes, it's the same
the secretary mentioned that she has the files here. We're going to look up and see what the previous house was.
Okay.
In fairness to you, I mean. Because right now you're 24 foot plus 4, so you're 28 foot wide. All right, we're going to recess for about 5 minutes while she looks this up.
Okay.
We looked up a few things here on the previous. So we do know the dimensions of the house that was there before, and that was 20 feet 5 inches. That was including the deck, wasn't it? Or no, without the deck. So it had 4-foot staircase on the side, so total was 24.5. Right now, we have a house that's 24 foot, and the steps are 4 foot, so we're up to 28 foot. So there is a difference. You're not within the original footprint. And the house is under construction right now, so this would be the time to make things correct.
Yeah, but didn't I see your foundation in already?
Yes, it's just about complete.
So the piers are poured already, or?
Well, the grade beams are poured, most of them.
At the 24-foot width?
Yeah, they're approved.
Mr. Chairman, what we don't have is the approved special permit plan. So if you're looking for the latest set of approvals, we need that special permit plan. Just 1 minute.
We'll take a few minutes to look for that.
Do you want a copy? I'm not sure if this is the special permit.
By looking at this, if we went with the approved plan that you have, I mean, the house can be 24 foot wide. But you know, it's a, if we didn't give you this variance right now, you can build things the way it was approved. But you can't have the rear staircase the way it's showing right here. It looks like before it must have been incorporated into the structure a little bit by those plans. Any other comments? Everyone took a look at it. What do you think? Any more questions? No? No? Okay, everyone, is there anyone here opposed to this application? I know there's no one here, but we have to ask that because there might be. Okay, this hearing's closed. Okay, we need your thoughts again. We need a motion, or I think we want to continue things. We always have that option, decisions.
I go back to my original. I mean, it's not a necessity, and this is, we're going to be confronted with this in the future when people want to connect, and I understand the desire to do so. But the original plans are approved by the zoning board does provide for an entry and exit and a way to do that with stairs and an approval. You don't need a variance from us. I know this would be very convenient to have it, but you know, if you wanted the 24-foot wide house, then you may give up the convenience. You had to give up the convenience. If you kept it at 20, then you could have had, you know, the connecting staircase. So I just don't see where the hardship is for it.
Mr. Soda?
Well, I feel the same way. Your old house was 20 and a half feet, and you chose to make it 24 feet. So you've added that for living space, and now you're coming back to us and asking for extra on the outside for convenience. Can't have it both ways.
And again, it's a precedent that this board sets, and it's not like, I mean, we can have statements that people say everyone else is doing this. Well, they're not doing it unless they come before this board, and we're just trying to keep some structure along the coastline and how close the houses are to each other, I mean, for emergency reasons also. So we need a motion.
Make a motion to deny.
Second.
Reason for denial, there's not a hardship. The property's already been approved for entrance and exit and accommodation with the staircase.
We have a motion to deny, and we have a second on the motion. Ms. Fronte?
With the motion.
Mr. Haberman?
The motion.
Mr. Vicino?
With the motion.
Mr. Soda?
With the motion.
I'm with the motion. Denied. Do we have any old business? Do we have any new business? No? Staff update? We always have a staff update on here. We don't have any staff updates. Did we read the minutes from October 13th, 2015? We need approval for those minutes?
Make a motion to approve the minutes as read.
Okay, all in favor? Aye, okay. Applications for December.
Right.
We have,
We have an appeal coming.
108 Beach is coming in. The one
108
that-
Beach is coming back.
There's a simple variance.
990 Naugatuck.
990? Oh, right, yes, of the violation.
That's two appeals.
Two appeals.
990 Naugatuck is coming back for what?
A new thing.
To appeal a decision. Now this is a new
This
one.
is a new decision.
Okay.
And there's a simple variance.
Okay. Anything, okay. So we have,
So far.
we already have 3 items for next month, so let's hope it doesn't go too much. And the one we continue, so we have 4 for next month. Do we have a motion to adjourn?
Make a motion to adjourn.
Second? Anyone? Second? Okay, this meeting is adjourned.